My Lord, may it please your Lordships. I appear on behalf of the appellant. I'm assisted by my Leonard Jr., Amanda Cliff Matthews, and Miss Simone Smith-Bean appears from the Bermuda Bar, who's on his behalf. I'm instructed by Parvez Jabber of the Death Sentence Project, and to his right is Angela Shaw, who's attending in case any matters arise that need to be dealt with during the course of the hearing. My Lord, the Crown are represented by my learned friend, Mr. Tom Poole. He's accompanied by Maria Safianos, who was the junior counsel at the trial, and Miss Nicole Smith, who works in the DPP's office in the Bahamas. My Lord, this appellant appeals by leave of the board, granted on the 3rd of April of 2020, expressly and solely on grounds 1 and 3 of his petition relating to the admission at his trial of evidence concerning gunshot residue, or GSR. The appellant and his co-defendant, Jay Dill, were convicted on the 25th of February of 2013 after a 4-week trial on the 28th of January, from the 28th of January of that year, of the premeditated murder of Randy Robinson some 2 years earlier on the 31st of March of 2011. And they were also convicted of using a firearm. My Lord, may I make some background and introductory remarks? The issues concerning the admission of particulate evidence relating to gunshot residue have been considered in the United Kingdom courts, most in the celebrated case of Jill Dando, that is the case of Barry George in November of 2007, which your Lordships have at the electronic bundle, page 3582. When consideration then was given to the guidance of the United Kingdom Forensic Science Service, which had been issued in 2006. In that case, the court were concerned with a single particle of characteristic gunshot residue, namely the full 3-component lead, antimony, and barium, said to derive from a single shot. In broad terms, the court allowed the appeal, having regard to the manner in which the particulate evidence was left to the jury. The issue came back for consideration again in 2015 in the case.
Am I right, Mr. Wood, that the particle was found in Barry George's case quite a while afterwards?
Well, my Lord, I don't know that detail, but that may well be the case.
I think you'll find it was a year after the event.
Well, my Lord, in Dwayne George,
Yep.
there were again the consideration of the 2006 guidance, and that concerned 2 particles of characteristic GSR, gunshot residue, of 3-component, and 2 particles of 2-component gunshot residue, described as consistent with GSR. In that case, again, the court allowed the appeal, having regard to the directions given concerning gunshot residue, having admitted the fresh evidence from Angela Shaw. Over that period, my Lord, since the scientific community has developed guidance to seek to secure uniformity on the approach to the giving of gunshot residue evidence throughout the world. We now have, in the materials before the court, your Lordships have the guide of 2006 contained in the case of both Barry and Dwayne George. You have, my Lords, been recently provided by the Respondent with a 2007 summary of a 2005 conference held by the FBI's Laboratory on Gunshot Residue, appended to the latest report of Mrs. Levine, or Miss Murtha, and Miss Helsels, served last week. We have formulated a detailed response to that report, and Ms Shaw has supplied a report to deal with apparent errors within it. My Lords, you also have the 2011 informal guidance from what is called the SWGGSR, that stands for the Scientific Working Group on Gunshot Residue, which was relied upon by Ms Martha Leneb during her evidence at the trial. My Lord, sometime before November of 2016, some 3 years after this appellant was convicted, the firm of experts instructed by the prosecution, R.J. Lee, decided to cease to report the presence of single component particles commonly associated with gunshot residue, commonly associated being the term used in the guidance. Because, as was said by Ms Helsell, their expert, in a trial, one components by themselves are not very probative. Since that decision was taken, you also have the formal guidance illustrating effectively worldwide standards for the detection and reporting of this evidence given by the American Society for Testing Materials, ASTM, which have come into place since the appellant's trial. My Lord, you have the 2017 guidance, number E1588-17 for the year. It's at the electronic bundle, page 3866 to 3870. You also have the 2020 updated E1588 guidance, an analysis guidance, in other words, to the person making the analysis and not reporting, which you have at pages 3871 to 3875. And finally, you have, my Lords, the guidance on reporting, which is at page 3436 of the electronic bundle, produced in September of last year, and giving rise to Ms Shaw's last and third report. It's the reporting guide and gives guidance as to how these matters should be reported.
And that's ASTM as well, is it?
It's an ASTM, yes, report.
Can you help me, please? I didn't make a note of it. The 2007 summary of the FBI conference to which you referred.
Yes.
Where do we have that?
Well, my Lord, you have that in a separate document, and I hope I can quickly identify where it is. It was submitted under the title of R.V. Hewey and the Queen, Report by R.J. Lee Group, updated. And it's a PDF of 26 pages, which exhibits the report. And I'll take you to the core of what's said in due course within it, my Lord, but it's annexed to that report, which I believe came before the court last week, and to which Miss Shaw has now responded.
There's an annex to it, isn't there, Mr. Wood?
That is the conference report which I'm referring to, my Lord.
Well, I don't seem to have that.
I can't find it, but that's probably me.
I may.
It's page 8 of the bundle, my Lord.
Yeah, it goes as far as 7.
What's the title of the electronic file that we were sent?
The title of the electronic file is 22.1.28, Hewey versus the Queen, Report of R.J. Lee Group updated, and it has it's a total of 26 pages long, and it starts by appending the report.
Oh, there, yes.
And then gives an annex summary.
The report dated the 21st of January, is that right?
It's the report dated the 21st of January,
yes,
with the annex to it.
Yes. Yes, we've been sent that, and it's on all our shared drives.
I'm very grateful, my Lord, because I was fairly early on in my submissions going to take your Lordships chronologically through the development of the guidance and take your Lordship to that.
Thank you. Well, if when you get to it, you call it the report by R.J. Lee Group,
I will do.
then we can easily find it in our
I'm very grateful.
file.
My Lord, we submit this case is the first to come before the Board concerning the reporting of and the giving in evidence of very large numbers of single component particles, commonly described as commonly associated with GSR, and limited numbers of two component particles described as consistent with GSR, said to be detected upon a wide number of distinct exhibits from the defendant's seized items. You have the list of those items, my Lord, and the quantities of component particles seen in a schedule, my Lord, which can be found at the electronic bundle, page 3384, through to 3391, which lists the findings of the items on the appellant Hewey.
Have we got the similar one for Mr Dill, Mr Wood, or not?
Well, I don't believe your Lordships have. We do have one, and if your Lordships...
You must have it here.
Yes, we do have one, and if your Lordships require it, I'm sure it can be provided in a form to assist if your Lordships need it. But the case, when prepared, it included that schedule which related to Mr Hewey's. The fresh evidence before your Lordship, we suggest, proves effectively for the first time that which had been suspected for a long time by those experts concerned in establishing the proper approach to the reporting of gunshot residue results, namely that one component particles, those described as commonly associated with GSR, and two component particles consistent with GSR are present in large numbers in the community in Bermuda, and indeed everywhere else. And in saying that about Bermuda, the tests have been done in Bermuda, but I cast no aspersion towards Bermuda in that respect, if I can make that plain. This, we say, is a worldwide position and not restricted to these items in Bermuda. My Lords, Miss Shaw's first report was in the form of questions and answers, and her question 14 at the electronic bundle at page 3407 draws attention to the fact that some 3 years after this applicant was convicted, in 2016, there was a small study when 6 samples were taken from Bermuda Airport. Similar results to these had been confirmed in small-scale studies abroad. She discloses that in 2017 there was a US study of prisoners and law enforcement officers, and more widely in Europe, and that's at page 3408 of the electronic bundle, giving some further information concerning the prevalence of these particles and even characteristic, that is, the full 3 component particles within the wider community.
Is it said that prisoners are, as it were, a random sample?
Well, my Lord, I will come to the studies that have been referred to, because indeed, helpfully, the respondents in supplying the annex to which I referred to that report have enabled us to see something more of the history of which hadn't been expressed, and I will take your Lordship shortly to it. My Lord, in her second report, provided in September last year, she provided the results from stubs collected in Bermuda in 2019. The results are, we suggest, in reality remarkable. They're set out in detail, and you have the schedule at the electronic bundle, page 3419. And they show, we submit, such a high prevalence of 1 and 2 component particles, effectively as to be wholly compatible with the levels detected upon the clothing and possessions of this applicant, including the motorbike, which was said to have been ridden by him to the scene of this shooting, such as we suggest wholly to negate the approach that was adopted to these 1 and 2 component particles by the learned trial judge at the trial. We say, had this material been available at trial, we submit the 1 and very probably the 2 element particles would never have been admitted. We do say that upon this topic, the assistance of this board is particularly needed as to the proper approach to this evidence. Our researches indicates that it appears that different jurisdictions within the Caribbean have adopted somewhat different approaches to the admission of 1 component, commonly associated with gunshot residue, and 2 component, consistent with gunshot residue particles. We've recently supplied your lordships in a supplementary bundle 2 authorities, one by the name of Augustine from Turks and Caicos, which appears to set out clearly, and we've referred to this in the note, the last paragraph of the note which we served yesterday, I'm afraid to say, in response to the report that was served.
Is this the 26th of January supplemental bundle?
It is, yes, with 2 cases in it, indexed in it, the first of which is Augustine.
Yep.
And Augustine, in the paragraph referred to in the note, makes clear the approach that 1 and 2 component particles are not routinely admitted, as appears to have been the established practice within Bermuda.
Sorry,
But
within Bermuda?
The established practice of admitting them routinely in Bermuda. My Lord, we understand a similar position is adopted in Jamaica. We've sought to make researches elsewhere, and it may be that other jurisdictions within the Caribbean have not ruled upon this because they don't actually have access to the science that enables this to happen. But, my Lord, that was the limit of our researches. Bermuda, though, appears to have in the past been routinely admitting this evidence as support for cases involving other key aspects of evidence. And I say that because in this case, our submission is that this really was, and I will come to it shortly, the key aspect. This case is unusual, for we submit the particulate evidence was the key and effectively only evidence which could have properly led to a conviction. Our case, my Lord, our reply to the respondent's case, and our reply served, I apologise, yesterday morning, our reply to the report submitted on behalf of the respondents last week are detailed. They all have links with cross-references to parts of the transcripts to which we refer. And can I make it plain, my lords, I certainly, in taking your lordships through our case, do not propose in oral argument to take your lordships to all of those transcript references, for to do so would be tedious. But I ask the court, effectively in private, if it has not already done so, to follow to those links to the evidence and the rulings when assessing our argument in due course.
Mr. Wood, parties have operated a fairly open house approach to the fresh evidence so far in terms of putting it in. There's been no ruling, I think, one way or the other as to whether any of it, or any particular parts of it, or how much of it should be admitted. And as at this moment, you probably know, but I don't know, the extent to which the admission of any of it is or isn't opposed. Furthermore, there may be all sorts of questions as to what forensic use the board can make of it,
Yes.
since I'm not aware that there's any application for cross-examination in relation to it.
No.
So it will help us to have, as we go along and at a time of your choosing, submissions as to whether it should be admitted and as to what use can be made of it. As I say, I'm assuming that you know where Mr. Poole stands so far as its admission is concerned.
My Lord, his case opposes the admission.
Yes.
And my Lord, my submission would be that the correct approach for the board would be to hear its de bene esse, and having heard it and understood it, then make rulings at the conclusion as to the admission of it.
That's how we've been preparing for the hearing, and we are, I think I can safely say, content to continue with the hearing on that basis. But as I say, we will want to have such submissions as either of you wish to make about the procedural aspects.
Well, my Lord, we do deal with it in our case, and when I come to that, I will indeed deal with it.
Could I just flag this up, Mr. Ward, because I'm not asking you to help us now, but as we go along in your own time, if we've got Ms. Shaw's several reports, which you filed, and we've got a response report from two other experts. If it should turn out that there is a difference between them, could you perhaps, as you go along, tell us how you want us to approach that? Can hardly resolve it, or can we resolve it on paper or not?
Well, my Lord, our submission would be that your Lordships can appropriately resolve it on paper, that these are all experts and taking a different approach. Your Lordship should be aware that the report served by the respondents is in fact drawn by two witnesses who appear in the evidence. Yes. So although she's now married, Miss Merthyr, as I knew her throughout the preparation of this case, I think is now Miss Leven or Leneve. I apologise to her if I've got it wrong. Miss Helsell appears in the original fresh evidence application because it was her who finally disclosed in the case of Trott that they had ceased to adopt the course which they had previously taken about the reporting of one-component particles, which effectively came...
Well, I understand all of that, but it's not what she says in the report that Mr. Poole has filed. And my question is, what are we to do if there turns out to be a difference between them?
Well, my Lord, I would wait to hear the respondent's response to it. We've made a detailed response to it, and Ms. Shaw has, but I certainly would not get into why, perhaps what I would say on the expertise, a more extreme approach appeared to be being adopted in that response. My Lord, our grounds are set out in paragraph 1.6 of our case. Without the fresh evidence, they are that the trial judge wrongly admitted the evidence of the one-component particles and the two-component particles of lead, barium, and antimony found on the appellant's person and his possession, and that evidence was highly prejudicial and had no probative value, and that the evidence was excluded. Our second formal ground is, having admitted that particulate, the trial judge's directions to the jury on that evidence were inaccurate, imbalanced, and unfair, in that the directions did not reflect the evidence of the gunshot residue expert called by the prosecution, nor the evidence of that called on behalf of Mr. Dill, but instead effectively inflated the value of the evidence of the one component and the two component particles. And his directions did not include some key aspects, we say, that pointed away from the appellant, and indeed never said what we say should have been said by the experts, that the absence of three-component GSR, in other words, gunshot residue, is something that supports the contention that someone did not fire a gun. My Lord, I started by saying that our submission was that this case was unusual in that it depended principally and mainly, we submit, on gunshot residue. And I thought it would be right to start with attempting to deal with that aspect of the case. And I'm going to turn, if I may, to the facts of the case. The prosecution case was, we submit, a weak one. Our submission is that at trial, there was no sufficient evidence to link this appellant to the shooting, and that it was only in the inappropriate elevated status of gunshot residue evidence which was core to the case being left to the jury. We submit that nothing else could begin to identify this appellant in the role attributed to him as the driver of the motorcycle from which Mr. Dill was said to have shot the victim, in this case, Randy Robinson. Your Lordships have electronic bundle, page 3375, 23389, a summary of the facts. It sets out the facts as led at trial.
Is this an agreed summary?
It is an agreed summary, is my understanding.
Yes.
It's not agreed.
No,
I do apologise, my Lord. I had understood it was an agreed summary.
In which case is it your summary?
It's our summary, my Lord. It's our summary. The items seized pertaining to this appellant were principally seized at his home address in the early hours of the morning. The object of the search had been to find a gun and to look for clothing that matched the description of the clothes Mr. Busby, the principal prosecution witness, had said had been worn by Mr. Robinson's assailants. Neither of the jackets worn by the appellant of Mr. Dill that evening, we submit, matched the description Mr. Busby had given. Mr. Dill's black and red jacket, the one that actually had the underneath, yes, the jacket underneath.
Sorry, underneath what?
Underneath the overjacket, the black overjacket.
So he's got something black on top.
Something.
And the red and black is underneath, is it?
That's my submission.
Right. And when you say that, how do we know that? Because he wasn't arrested wearing it, was he, or was he? He was.
He was. Sorry, I may turn to my learned junior, yes, who is a master of the facts, and I hope I've got there sufficiently, but I thank her for not only the work she's done in pleading this case, but also in the encyclopedic knowledge she has of the facts of it.
So the red and black one is
the one with the positive GSR on it.
I thought there was a tracksuit top which had the positive on it, and there's a red and black jacket which is collected on the following Monday.
Yes, that's it.
And But you say he was arrested wearing both of them, so he must have taken something off.
Sorry, I'm going to sit down.
Yes, my lord, yes, so the tracksuit top was black, and that was underneath the red and black jacket that he supposedly wore on top when he was on his motorcycle and allegedly carrying out this shooting. So it was the tracksuit top that had the component particles, three component particles of GSR on it.
Is that Exhibit 27? Is that Exhibit 27, WT3?
WT3, yes.
So that's the tracksuit top, is it?
Yes, it should be labelled.
WT3, Exhibit 27,
That's fine, yep.
page 195 and 223.
Yep.
And the red and black jacket, he must have then taken off in the house and left it behind after he was arrested.
Yes, and because it was later taken from the house.
Yes.
After he informed.
And that's WB21 Exhibit 23. Is that right? I mean, we better get it right before we go much further. WB21 Exhibit 23.
I thought it was Exhibit 3, but anyway.
Ah.
Can I just check my schedule?
221.
221, certainly.
No, red and black jacket, Exhibit 23.
It's 23, is it?
Yeah.
Very much indeed. Thank you.
Which has also got a sorry, no, it hasn't. No.
It would be useful to know what was found, to have a similar schedule in relation to the items of clothing.
My lord, we can supply that to your lordship, and it is in existence, and we can certainly supply it to your lordships.
Well, there was plainly one that the jury had. You can see that.
Well, my lord,
summing up.
That has been a request of mine to Miss Smith-Bean as to whether such document could be recovered, having read the transcripts. And I'm afraid to say we couldn't find the actual trial documents in relation to it, and have done our best to create it. Can I ask the question, as inevitably in the light of the questions, this schedule will have to be served. We have paper copies here, but as with other documents, it may actually be easier if your lordships had it electronically. I don't. We can certainly supply paper copies.
We would certainly like it electronically, and if those instructing you email it to the registry, it will turn up on our screens reasonably quickly thereafter. But if for any part of your submissions you need it now, then by all means circulate it in.
If it's in the same form. I
don't need it now, my lord, because I was certainly going to concentrate on the material so far as Mr. Hewey was concerned. Right. My lord, in terms of reviewing the extent of the prosecution case, we submit that actually it's perhaps best to see how the respondents put it. And they, at page 3546 of the electronic bundle, at paragraph 60, summarize their contention that without the gunshot residue, this case was a strong one. And my lord, we propose to simply go there, 3546, it's towards the end of the respondent's case, under the heading of proviso, where they set out the core elements that they say were rested in the case, and I rely upon those in my submission that this was a weak case that required the glue of one component and two component GSR. My lord, the elements were that there was evidence that the appellant was a mid-ranking member and soldier of the 42nd Gang, and as such was expected to conduct revenge attacks on those who were perceived to have humiliated or insulted a fellow gang member. Indeed, my Lord Hughes, you dealt with the case of Myers. This case dealt with exactly the same witness, dealing with exactly the same kind of evidence, between the same two gangs. So it's a complete replication of gang evidence.
Slightly different gangs, I think, but don't worry, it makes no difference to the submission.
There's certainly mentioned there. My Lord, what we say that motive evidence is that has been ruled rightly to have been admitted, was dealt with inappropriately by the trial judge, but cannot do more, and applies equally to all other members of that gang. There was, say the Crown, at paragraph C, in November 2010 at the Wellington Oval, an incident involving Mr Dill. It was said that he was humiliated in front of other gang members. My Lord, nowhere was there any reference to Mr Hewey being present at or involved in that incident. D, the gun was used to kill the deceased, had been used by members of the 47 gang in other cases. And my Lord,
I think it was subsequently, wasn't it?
That's exactly my submission. It was subsequently by someone else, unassociated with this appellant.
Now, what, if anything, can be derived from that?
Well, my Lord, we say nothing so far as this is concerned, and that is why I'm taking your Lordship to these aspects of the case.
Does it prove, for example, or does it not prove, does it tend to show, for example, that the gun in question was in common possession, in other words, a gang gun?
Well, it certainly looks like that, my Lord,
Right.
and I wouldn't in any way seek to submit otherwise.
And if that's right, does it have any bearing on whether this was a gangland killing?
Potentially, my Lord, potentially, but my Lord, still, it's not in any way specific to this appellant and this case. These are features. If one goes to Myers, my Lord, one's dealing with identification evidence centrally, to which these are added. My Lord, there was said to be telephone contact. It's effectively disputed so far as this appellant is concerned from looking at the schedule, which your Lordships have at the electronic bundle, page 3303. There's modest telephone contact with a man called Paris, who the evidence of the officer was that he was a gang leader. Mm-hmm. My Lord, so far as this appellant is concerned, there was simply one attempted call appearing on that schedule in terms of contact at around the time of the alleged shooting.
That's 8:32, is that right?
That's right, yes, my Lord.
And at the same time, Mr. Dill is on the telephone.
Absolutely.
To Mr. Paris.
Yes.
They were both trying to ring him up.
Absolutely, my Lord.
Do we know that in Hewey's case that the call was an attempted call by Hewey to Paris?
Yes.
At 8:32, which is as near as we know about the time as it happens.
No, my Lord, we would say the evidence discloses that the time of the shooting is earlier.
How much?
About 8:10 to 8:15, my Lord.
Really?
Oh, I'm sorry, I apologise. 8:25 is the time I'm giving.
Yes, okay.
The earlier, yes. But, yes.
So within about 5 minutes of the shooting then. All right. But if that's Hewey's call. What about the Dill calls? Were they from Paris to Dill or from Dill to Paris, or don't we know?
Well, my Lord, what the schedule discloses is that they are from Paris to Dill on 2 occasions.
So, and the timing of those?
8:32 and 8:43.
832.
And 843. And, my Lord, your Lordships can see this at page 3306 of the electronic bundle.
That's kind, thank you. Yeah.
And when your Lordships are on that page, the call by Hewey to his mother, put the dog out, is at 5 to 9.
5 to 9?
5 to 9, 2055, my Lord, towards the bottom of that page.
So, as far as telephone calls are concerned, we've got Hewey making a call to Paris which goes to voicemail, so doesn't get through. But of course, Mr. Paris would know that it had, or might know, that it had been attempted.
My Lord, and all of this depends upon Paris being somehow a principal in this, of which we say there was, in effect, no evidence at all.
Wasn't there evidence from Sergeant whatever his name is?
He said that he was a gang leader, yes.
All right, well, subject to that, of course, if he's nothing to do with the gang, it's got no significance. But Hewey phones Paris, doesn't get through.
Yes.
Voicemail, goes to voicemail, so Mr. Paris has access to knowing that Hewey's after him. And within, what, 3 minutes, 4 minutes of that? No, same minute. Same minute.
No, it's 28 to 32.
Well, Hewey's call is 2032, you said?
No, Hewey's call is 2028.
Ah, thank you. Okay, so it's 4 minutes later.
4 minutes later.
Paris calls Dill.
Yes, Paris calls Dill after having been caught making other calls. 2 other calls can be seen to be being made by Paris.
Okay, thank you.
My Lord, there we have the telephone evidence, and then effectively the Crown say there was a similarity, a potential similarity in clothing. They rely upon the call which I've dealt with to the appellant's mother, and then the time of arrival of the appellant with Dill at the address, and the fact that the appellant...
So it's within about half an hour, is it, that they turn up at Hewey's house together?
Together on separate motorbikes, both of which are analysed.
Then I suppose you've got the fact that, in common, no doubt, with others, Mr. Hewey was using a black Scoopy that night.
My Lord, a black Scoopy is the most, and if Miss Smith-Bean has brought any information to me, it is that in Bermuda it is the absolutely used on numerous occasions.
Yep.
My Lord, so we submit, looking at that, what is it that could possibly create a case against Hewey on that material? And we say it would inevitably be discharged at the close of the prosecution case.
What is the relevance, if any, of the 3-component, and indeed 2-component, residue found on Dill?
Well, my Lord, that's...
And his bike.
Not and his bike.
Well, is it all 1 on his bike?
I think it's 1 and 2.
1 and 2, yes.
1 and 2.
So. Exactly. So what, if any, is the relevance of... Actually, I think it may only be 1 on his bike. Yes. Oh, no, there's a 2 on his bike.
My Lord, we say, and let me make my submission absolutely clear so far as 1 and 2 components and all those 1 and 2 component cases, is that if you look at Miss Shaw's evidence, you get a similar kind of distribution to that which you actually get in relation. And so the doubts that are expressed about 1 should be read as actually being expressed about 2 as well. They are there, extant, less frequently. And in her survey of 20 items, she came across 2, 1 lead and barium. We put it down as both lead and antimony. 1 is lead and barium, and 1 is lead and antimony. But she came across in her survey in the 2018 stub collection 2 component particles as well, to a similar proportion, we would submit, to those which are actually shown on this distribution of items recovered in this appellant's case.
So, I'm sorry,
No, it's...
I diverted you. But what, if any, is the relevance of the findings of three-component particles on Dill?
Well, my lord, we say that that cannot make a case against...
Does it add to it at all?
Well, my lord, I think our position has to be no, not because, but if it does, it's marginal and contentious, my lord. I can see all sorts of arguments that may prevail so far as that is concerned. But, my lord, we say even if you took a worst-case scenario on that, so far as establishing that Hewey is the driver, the man who gets the gunman to the scene, it's not there at all. And that's why we say this case, unlike the others, where there's always been either someone who says what happened, who can identify people, or there's some core linchpin piece of evidence. My lord, we make those points in chapter 8 of our case, and I'm going to deal with it now. Electronic bundle, page 3367.
The finding of 1 and 2 component particles in association with 3 component doesn't have to be on the same sample. I think that your witness describes it as being in the same population.
Yes, and
then if the jury were of a mind to accept the evidence that they arrived together at the house, that they were in each other's company throughout that evening, and accordingly, if one was on the motorbike, both were, wouldn't that be the same population?
My lord, we say absolutely not.
Right.
And the reason for that is because of the manner in which the exhibits are collected, the different way in which they are handled. They're being seized by all sorts of different people. And, my lord, we say population, effectively what population is being used for is to assist in the interpretation of the GSR itself, the 3-component. And so, my lord, what population can do is, say you have a jacket, and you find 4, on one stub you find 4 GSRs, full GSRs. And on other stubs, you find 2 and 1 component. Then, my lord, it may assist you in saying, well, actually, that is all consistent with a shot doing this. In those circumstances, my lord, my understanding, and I'll be corrected if I'm wrong, then one might be able to say, yes, I look at the 1 and 2 component particles, and I can say that from that distribution of that number there, it lends support to the fact that this isn't, as it were, a contamination. This is a gunshot. But, my lord, when one's dealing with diverse, separate items, it cannot, in our submission, assist in any way whatever with the interpretation of the 3-element gunshot residue.
Do we have anywhere a definition of population?
Well, my lord, I'm going to... my lord, no, absolutely not. Save, there is one place, and I have to say, my lord, I put it in with trepidation because it was my drawing as to what we would say would be. I pressed Miss Shaw upon this. There is no actual definition of population, but in the very last paragraph of paragraph 8 of the document we served yesterday, I made an attempt at saying something about that. At paragraph 8.5, my lord. Then this, I make it plain. This is a definition that it is not in any way sourced, but is an attempt to encompass what we understand to be the science, that one cannot eliminate the the possibility in all circumstances of using 1 and 2 component. But the key, and I've sought to identify there the key components. But, my Lord, I make it plain that any definition must be something actually for the science community to put together, and it might be better effectively to rely upon what is said by Miss Shaw in her third and final report about the circumstances in which population can be used. But that, in that paragraph, was simply my attempt to try to pull that.
While you've got it open, Mr. Wood, can I just flag up something which you may well be going to come to, so if you are, take it in your own time. But that 8 little Roman 5, you are founding on para 556, which is 556 of, I think, E309
Yes.
of the ASTM guidance, isn't it?
Yes.
Clearly indicates particles commonly associated, i.e. one component, can only be interpreted and thus given evidence if they're detected in conjunction with characteristic, i.e. three component, and consistent 2 component. Now, you've used the conjunction and,
Yes.
which is how it appears in 3309.
Yes.
At some point, I'd be very grateful if you'd examine whether that means in effect and or, because if you look at the other guidance documents, it rather looks as if it might. But come to that in your own.
Well, my Lord, I'm going to bite the bullet on that point. I drew it because that is the term, but Miss Shaw says effectively it's an or.
She does, doesn't she?
She does, yes, she does.
Yeah.
Yes.
Thank you very much.
And therefore, my Lord, it would be completely wrong of me to do other. But
thank you.
my draft is drawn as, and it's nothing more than my attempt.
The direct quotation from 556, no problem.
Effectively, but it goes slightly further than that in the sense that it tries to draw the kind of circumstances in which it might be possible to do the kind of action that has been spoken about, rather than what I'm going to submit has been Miss Murtha's practice, to say if anything ceased at around the same time and the same occasion, we can look at them all together. And that even applies to clothing that was not being worn at the time. And, of course, the clothing that was not being worn at the time, my Lord, proves our background point, or potentially proves our background point, because if it comes up, as it does on a number of occasions, with 2 and 1 particles, it establishes the background point. But
forgive me, I'm not sure I'm understanding this. Is it the case, therefore, that from that reading of 556 on page 3438, that the existence of a single of 1 component particles in conjunction with 2 component particles may be significant so far as the source of the single component particles is concerned?
Well, my Lord, we would submit that an expert would be hard-pressed to go there and to admit it on that basis, because in reality, my Lord, what one's looking at is here 2 component particles and 1 component particles being in the community anyway. And so one would have to have a number that was wholly inconsistent with that in order to be able to start to say, well, actually, as we have here on my client, I think it's 3 2-component particles in all of those items, right, to try and qualify that by saying, well, actually, there's quite a number of 1-component particles. There may be circumstances in which it can be done.
I understand that point, but subject to that, 556 admits the possibility, doesn't it?
Well, as do all the other regulations admit the possibility, but it's all about qualifying and establishing actually 3-component particles.
But we're on admissibility, Mr. Wood. Your core submission is that courts ought not to be troubled ever by either 1 or 2 component particles unless there are some 3s. Is that right?
My Lord, that is my course of mission.
You say any judge faced with it should say, absolutely not.
Absolutely, my Lord. And any attempt to, there may be, I'm going to caveat that, because there may be exceptional circumstances where someone could say, actually, I need to put these in to establish the actual context of these three component particles.
Well, that's if there are threes, yes. But your core proposition is that unless there's a 3 on Hewey, then none of the rest ought to have been admitted at all.
That our core submission, my Lord, is absolutely that.
Well, now, how does that square with what my Lord has just pointed out is what 556 actually says?
Well, then, in those circumstances, what one would be doing is excluding all the isolated singles, the vast majority of items.
But they're not isolated if they're found in the same place as a two.
No, my Lord, the point that I make is, what is the same place?
Oh, I see. Well, all right.
What is the same place, my Lord?
Right, okay. But if they are found on the same object, for example, would you say they have to be found on the same sample?
My Lord, I've already qualified that.
I thought you said
the same object.
Same object.
The same object, my Lord, is what effectively, but our submission is that it would never be probative because two component particles alone cannot establish that it's GSR. That's why we take the principal point that two component particles and one component particles of themselves should never be admitted. If you have them alone, my Lord, they should never be admitted. Their role is simply to qualify the circumstances of the three component particles. And so in my submission, the way that one should approach this, and the expert community is, as is the experience now of R.G. Lee.
You may be right, but it's not what 556 says. 556 says, and so do all the other guidance documents, that you can use the ones to qualify not only the threes, but the twos.
My Lord, to qualify to show what? To qualify to say that they're reportable, but not that they're probative.
They tend to support the origin being a gun.
No, they never do that.
Is that not what 556 says?
No, my Lord, because the two component particles do not of themselves support the origin being a gun.
Well, no, you see, they do support it. They don't prove it. And if it comes to that, even the three component particles don't prove it. They're simply a lot stronger than the twos.
No, my Lord, I want to really try and...
Yes.
The three component particles are gunshot residue.
Well, they're treated as such by the scientists, but all the scientists accept that you can occasionally get them from something else.
And it's in those circumstances, when they're alone, that the twos can assist and the ones potentially can assist.
I see. All right.
My Lord, if it assists your Lordship as to how I would envisage this happening, is that if in any case a scientist wished to admit, or a prosecutor wished to admit, one or two component particles, they would have to explain clearly why it was relevant and probative to do so. And in our submission, because they do not prove the source of a firearm, they are not admissible ab initio, unless one can establish the circumstances that will permit them to be admitted.
Absolutely, you're inviting us, I think, to deal with this fairly broadly, and indeed to give guidance to half a dozen different jurisdictions around the Caribbean on the strength of this. Do you accept that what you've just said is, it might or might not be right, I mean, I just don't know, but it's a gloss, isn't it, on what these various guidance documents say?
Well, my Lord, we say it's the proper interpretation of those guidance documents.
Yeah. All right, thank you.
My Lord, I'm past the note which simply said Mr. Dill was arrested by armed officers, and of course that's
a different point.
I completely agree with that.
Yep.
Yeah. My Lord, I was dealing with the strength of the case.
Yeah.
And I wanted to take your lordships to the way that we dealt with that in our case at page 29, paragraphs 8, 2, 3, 4, and 5. And our riposte, as it were, to the Crown's case as to strength.
Sorry, paragraph of your case?
8.2, paragraphs, page 3367, page 29, small 29.
Yeah.
My Lord, we've sought there, and did so in advance, as it were, to answer the points that were made by the respondent, and I do stand by the submission that I've made. We deal with the particle evidence at 8.2. We deal with the motive in the second half of 8.2. And at 8.3, 8.4, and 8.5, and over the page through to 8.8, we set out in writing our submissions.
Do we have to put into this or not Mr. Dill's voice note?
Well, we say they're never admissible. The reality of...
Why not?
Well, they're admissible against Dill.
No, but why aren't they admissible against you? If the evidence had been that Mr. Dill had been standing in public somewhere telling people in general in the pub that he was likely that he was a candidate to shoot somebody, why isn't that evidence which is relevant in your case? If it is then demonstrated...
If we were being tried alone in our submission, it would not be admissible.
Wouldn't it? If the evidence was that you were found with Dill and had apparently been with him at the time... You say not.
We do say not, my lord.
Yep.
But I can certainly hear what your lordship's saying, that it may be a matter of some argument.
That's helpful.
But, my lord, we do say, centrally, this case was one where, unlike all the other cases in these circumstances, where this evidence had really the only bite in the case.
Yeah, okay.
Let me just bring you back to, if you have two people on a motorbike and all their clothes are taken at the same time, perfectly properly, why is it, and say for instance you have a witness who sees two people on a motorbike and identifies them, why is it that you say that the driver is not in the same population as the pillion passenger?
My lord, it's answered by Miss Shaw's latest report. It's in a separate tab. It's the Monday morning tab.
Is that what it's called?
Yep.
With our note, with the paragraph that I took your lordships to.
What, 8 Little Roman 5?
Yes, my lord, I'm just trying to find it, where she deals with the hypothesis that is put.
Page 18.
I'm grateful. The hypothetical example is given, and then she gives the hypothetical example. The only circumstances in which all of the samples taken from the two individuals and the motorbike could be considered as one population would be if the two individuals and the bike was sampled immediately after the gun was discharged at the scene. We refer to this as time zero, as there has been no opportunity for anything to change in relation to any particles, firearm or no firearms related, that may or may not be present on the individuals and the motorbike. However, I understand that Mr. Hewey and Mr. Dill were arrested approximately 6 hours later, as is true, at Mr. Hewey's home address. The items were recovered from the address by the police, and 2 motorcycles were recovered in the garden. The time delay different locations of the suspects in relation to the scene of the shooting, and the different locations of the motorbikes means that any particles found on these items cannot be treated as a single population. To do so presupposes that the individuals and the motorbike were intimately connected to the shooting. And my lord, in our skeleton argument, we dealt with the hypothesis where did we deal with it? Page 8, Roman 4. Page 8, Roman 4, yes, thank you, my lord. Fourth, the opinion, that is the hypothetical example, does not support the respondent's case. The authors state in the last sentence of that paragraph that different samples could be considered one population, assuming that the event did indeed occur as described in the hypothetical situation as set out in that paragraph. This amounts to putting the cart before the horse. Assuming a hypothesis is true, in order to draw conclusions about the particles, is not the same as drawing conclusions about the particles in order to prove that the hypothesis is true. As the appellant has previously submitted, whether the particles on the appellant came from a gun could only be determined after the jury were satisfied on the other evidence that the events described by the prosecution had been proved, and not, as is his trial, in order to prove that those events occurred. That, in our submission, is a key central submission to this.
For my part, I agree. You can't assume what's to be proved, but in this case, there might be the possibility of such proof. Insofar as they're both in each other's company, they both arrive at the same time, they both have the same motivations, potentially.
Well, my lord, we would say that when what one's dealing with, and I'll come to this in due course, but what one's dealing with is one, background levels of GSR particles, in other words, of 1 and 2 component. That could never be the case in the absence of 3 component particles. So, my lord, if I go back to our case at paragraphs 3,
electronic
page 3344.
Thank you.
My lord, this time at this stage I'm going to seek to take your lordships to some of the transcript by the use of the links in our case. At trial at 3-1, the appellant sought to exclude the evidence of the 1 component and 2 component particles for the reason that they added nothing to the prosecution case. The trial judge dismissed that application for 2 reasons, and I'm going to invite your lordships with me to go to the link on this at paragraph 3.1.
Could you just give us the electronic bundle page, or is that
842.
842.
842.
Thank you very much.
This is about admissibility of the particles. I apologise. The learned trial judge at 842, having heard argument on the admissibility of the particles at the outset, said that he thought there was some merit in the argument to exclude the single particles, that he thought at the bottom of page 842 that this is evidence that a jury should rightly hear. I think the absence of a further explanation at this time is not sufficient reason to exclude this material, and this is to do with the inadequacy of the report. And he at that stage ruled that subject to a further report from Miss Murtha, the evidence should be admitted in due course, subject to the finding of such a report. Such a report was filed, and I'm going to take your lordships to it. At page 791, my lord, and we submit clearly here, one can see the approach of Miss Murtha to this evidence, and if I invite your lordships to go to page 793, in her report, where she defines three particles, the three levels of particles at the top of the page. She describes 2 and 1 component particles could have come from the discharge of a firearm. And then she says this, my lord, at the bottom of 793. Even though it cannot be stated with absolute certainty that 1 and 2 component particles originate from the discharge of a firearm, my lord, we say that indicates that so far as she is concerned, she is giving them a weight that these particles can never sustain. She says these particles are still reported out because they could have come from the discharge. In other words, what she's saying is it cannot be stated with absolute certainty. In other words, it's highly probable that they do, and they could. When 1 component and 2 component particles are present with GSR particles, and this makes my point that contain lead, antimony and barium, that is full 3 component, it lends weight to the population of GSR particles present on the sample being examined. And my lords, in answer to the questions that you've asked, those words present on the samples being examined, in our submission give the clear linkage that there must be between 3 and 2 and 1 and the admission of the same. As such, these 1 component particles and 2 component particles do have an evidentiary value. And we say that is what we challenge in these proceedings. And whilst I'm on that page, can I take your lordship slightly further down to the paragraph in the middle of the page that starts the amount of GSR particles, 2 component particles and 1 component particles, found on the sample does not dictate whether or not an incident is more or less likely.
Well, that appears everywhere, I think, in scientific reports. And there's a complication with numbers anyway, isn't there, Mr. Wood? Because at least this laboratory, and for all I know, others as well, only do the final microscopic testing on the first 20 of each group of particle recovered. So you've no idea whether there's hundreds or even more of them. Just don't know about number.
My Lord, it's because, in effect, what one's actually looking for is one's looking for full hit GSR 3 component, and then seeing what there can be to potentially support that it's not a random, but it's the real thing. And that's where the errors have come in here.
Well, it may be as simple as the fact that it's a very expensive thing to do. If you've got hundreds of thousands of particles, you simply can't analyse all of them. But I don't know.
But, my Lord, what you're dealing with is the evidential value of those ones and twos. The amount of particulate found on a sample could be dependent on many factors, and that's common.
As a matter of interest, when Miss Shaw did her tests at the airport and in the various pubs, bars, where she found bits of this and bits of that, did she approach it in the same way by testing only the first 20, or is her list a comprehensive list of everything she found?
I think it's everything she found, but that is something that I can be informed about over the lunch and adjournment.
Okay.
And one of the reasons to be able to answer those kinds of questions that she's given her time to be here. My Lord, it was after that there were then submissions of no case after she had given her evidence about all the particles, and I'm at 3.3 of my our case, my Lord.
So, page number, sorry?
Page 3344.
Thank you very much.
The judge, in his ruling, in his ruling at page 2534 to 2543, which I invite your lordships to go to, obviously, we say, effectively gave the inappropriate interpretations that he was later effectively to repeat. And I invite your lordships to page 2534 of his ruling. He asserted, completely wrongly and contrary to the science, that, and this is in paragraph 331 of our grounds, that there should have been no GSR-related particles on the appellant or his clothing. And he does that at paragraphs 1 and 2 of his ruling. By his own mother's evidence, he took a bath that afternoon and put on what must be taken to be fresh clothes, announcing he was going out. There should therefore be no GSR-related particles on him. And my Lord, that bluntly is completely wrong. There will be particles on all of us at this time.
Well, you don't have to go that far, do you? There might be.
Well, there might be, but the likelihood is, my Lord, that there will be. Really? And one sees something of that, my Lord, when one looks at the various full negatives. You might not, on sampling, produce anything, but the likelihood is, we say, you would. He went on. She washes his clothes on a weekly basis, including his jeans, etc. There should, therefore, be no GSR-related particles on them.
I'm so sorry. I think I'm on a wrong page number. Where are you reading from?
2534.
Thank you.
And there was absolutely no scientific evidence for any of that, is that right? Or in the trial?
No, there wasn't. That was never said at all at any stage by Miss Merthyr, and I don't think she would have ever said that.
And he repeats that during his directions to the jury? He
does, my Lord, yes. He does. My Lord, the terminology, which is terminology that he repeated to the jury at plastered at item 2, over the page at 2531, those bikes are plastered in GSR-related particles. He refers to them, and here we submit there are real problems with the way this is addressed. While technically, and we ran into problems with Ms. Murtha's evidence about the use of terms such as umbrella and so forth, there was no distinction being made. They were all assumed to have probative value, whereas in our submission, the correct approach to this kind of evidence is that GSR, full 3-component, has probative value, and that probative value can sometimes be enhanced by the discovery of 2 and 1. My Lord, at the bottom of the page at 2531, in item 10 of his ruling, he said there can be no dispute that all the clothing and the items, and plus the WB jacket later collected from Mr. Hewey, were worn by him. They have GSR-related particles in plenty, all types and places of them. There was descriptions as to other sources. He, at page 2536, speaks about the helmets. Both helmets bear GSR-related particles. And goes on to say, I use the term GSR-related not to say they are definitely GSR, that is 3 particle components, but is like the expert in its global form means everything that comes out of a firearm, and say they could be discharged from a firearm. And because she only reported them after checking for and eliminating other tags, etc. My Lord, we say he's giving an enhanced evidential status to this evidence. And at paragraph 4, my Lord, at 2538, paragraph 11, he says in connection with Mr. Hewey, given that the rider was not the shooter, I find it not inconsistent or unreasonable at all that there should be less or little or even no particles upon him or his clothing at all. In our submission, you can't win one way or the other so far as this is concerned. He describes them as in an enhanced way. My Lord, we'll revert to the summing up in due course. But, my Lord, can I turn, please, to the fresh evidence about which we seek and formally address the fresh evidence at paragraph 4. The reports of Miss Shaw, including those most recently placed before the court, and the transcript of Miss Hessel's evidence is what we seek your Lordship to admit. And in making that application, should it be granted, I in no way seek to oppose the admission of the report served by the respondents, because what is sauce for the goose undoubtedly has to be sauce for the gander. We have set out in paragraph 4.2 of our grounds the effect of the fresh evidence. There were a total, I believe, of 316 one-component particles on the appellant, and his possessions had minimal, if any, significance to the detection of gunshot residue. That is our submission. It was, we say, incapable of assisting the jury when it came to determining whether the appellant had been in proximity to a discharged firearm. the 5 GSR particles found on Mr. Dill, we say do not support a conclusion nor make it any more likely that the particles found in respect of the appellant came from a gun. The particles did not give rise to an inference that, as the judge put it, the defendants got infested. And I'm going to take your lordships to that passage paragraph 4 to 3. It's in the trial judge's summing up. And it's page 208.
Thank you very much.
Starting at line 10, the prosecution, you may think, and of course the trial judge is postulating the prosecution's case, is saying, or is entitled to say, so it's positing it and it's giving it judicial imprimatur, that given the multiplicity of particles found on the various areas of these items, including up to 5 3-component particles on items of Mr. Dill, and 7 2-component particles, together with various 1-component particles, or all 3 elements found on items of both of the defendants, you should find that both defendants were involved in the firing of the firearm that night that killed Mr. Robinson. Particles on both cycles, almost all their clothing, in-out sleeves, hand, palm, shoes, helmets. You ought not to separate that kind of evidence and say this one has that but not this, or this one has more and this one less, and therefore he or the other is not guilty. My Lord, that passage indicates the force and strength, and if one turns over the page to page 209, they were in this together, planned and operated together, and got infested with particles together. And then he says, I think that's what the prosecution would want you to consider before going on. So that was his introduction in summing up to the residue evidence. We suggest that the fresh evidence of Miss Shaw in her 3 reports really assists the court. But before I go to her reports, can I take you through to the various elements of the guidance throughout the years, my Lord? And can I start with the bundle of the 21st of January of this year, and the report of the respondents, but the conference notes that are added to it and appended to it, my Lord, and it's the report at page 13, and I hope your lordships now have it, because I'm going to read the paragraph, the sentence from the paragraph that was cited. It's page 13.
I'm sorry, this is my fault, Mr. Wood. I can't find the document at the moment. It's a report.
It's a report that starts with 22-1-28. It's saved as 22-1-28 Hewey versus the Queen, report of R.J. Lee Group updated.pdf.
Annex the Lee report.
And it contains an annex to the report. And I'm going to take your lordships to page 13 of that document.
Sorry. The title again?
22.1.28, Hewey and the Queen, report by R.J. Lee Group, open brackets, updated, close brackets, .pdf.
How many pages are there in this extract?
26.
I've got it, thank you.
I haven't got it, I'm sorry. Report by R.J. Lee Group.
There are two reports by the R.J. Lee Group in the shared file.
26 pages.
And this is what was arrived on the 31st of January.
Got it. Thank you very much. I'm very sorry.
My Lord, the report starts at page 8 of the bundle. It's referred to by their experts, and my Lord, the passage which is cited in the report is that at page 13. It was widely agreed that the average person who is not exposed to firearms or ammunition or its components will not be found to have GSR particles on the hands. And that was what was cited by them and why the report was placed before your lordships, and they sought to use that proposition to justify the use of her evidence asserting that there was nothing, and it was unusual to find 1 and 2 elements. And Ms. Shaw has responded to that by saying that that is undoubtedly and clearly a reference to the finding of 3-component GSR, and not as asserted by the respondents, the respondents' experts, as relating to lesser.
Sorry, I'm looking at page 13 for the part that Ms.
It's
Shaw
the penultimate paragraph, my Lord.
Lovely.
The paragraph starts, "It was widely agreed." But this is a report of a 2005, and what it does is it also contains some of the standards that are applying at that stage.
Oh, I see. So the question is, in what sense they're using the expression GSR particles, is that it?
Yes, my Lord, but I'm deploying it at this stage to give your Lordship something of the history about this, because this paragraph also sets out usefully and helpfully the history. The issue between Ms. Shaw and the respondent's expert was whether that could properly be said to apply to non-3-component GSR, and she submits, and we say in context, it undoubtedly is referring to 3-component.
Well, is it? Because, I mean, you may be right, but I'm just reading the fourth line of it, the occupational study on 102 random individuals.
Yes, absolutely.
Somebody called for jury duty. One person had a 2-component particle.
Yes.
So that seems to be a discussion of a 2-component particle, does it?
Well, my Lord, if you go on, you can see what is actually being said about standards. These results indicate that a subject's daily environment can affect the likelihood of finding GSR. They then talk about James Garcia and an Army survey. Therefore, the Army Crime Laboratory requires a threshold of at least 4 PBBA-SB, that's lead, barium, and an antimony particles, to report a positive GSR result for these specimens. So, my Lord, that's 2005. The US Army Crime Laboratory is saying it needs 4. The threshold was instituted to allow for the possibility of casual contact by subjects with firearms in the performance of their duties. And that has to be said because, of course, that's an army. However, levels beyond this value would likely involve greater exposure to GSR particles, namely the recent discharge of a firearm. And that's 2005. The FBI laboratory has established a threshold for the number of GSR particles that is confirmed before an item can be concluded to have been exposed to gunshot residue. So this is giving us the information as to what the FBI laboratory was doing at about the time that Barry George was due to come up, or had been convicted and was due to come up before the Court of Appeal. The FBI laboratory has established a threshold for the number of GSR particles that is confirmed before an item can be concluded to have been exposed to gunshot residue. The number of particles used to confirm GSR populations is a minimum of 3 PB, BA, SB particles.
That's the FBI standard.
That was the FBI standard then. Additionally, other particles consistent with GSR type environment also must be present. In other words, what they're saying is not only must you have 3, but you must have additionally a number of 2 component particles, SBA, barium and antimony, barium and lead and antimony, and or other elements or elements composite routinely found in GSR particle populations. And I know not whether that is a reference to 1 component particles. It may be, it may not. The majority of the symposium participants overwhelmingly agreed that particles can transfer from one surface to another, and that bystanders, e.g. persons present at the scene of the shooting, etc. And I need not go further than that, my lord. But helpfully, what that report does is give us something of the history so far as standards are concerned. My lord, your lordships then have the SWGGSR, which stands for the Scientific Working Group on Gunshot Residue. This is indicated to be a report in 2011. That body no longer exists, and this has not been updated or modified since 2011, but it was that which the experts had at trial and were referring to. My lord, I take you to page 16, classification of GSR, page 3891. Classification of GSR is the heading that I'm going to go through, and this is effectively what has in due course been adopted in the further guidance that has been given. The following classifications, and then it sets out the classifications, and over the page we will see for the first time the guidance as with the common elements. Particles classified as commonly associated with GSR have compositions that are also commonly found in environmental particles from numerous sources. And I should go back to deal with consistent, which is the 2 component, which is at the bottom of page 3891. Particles classified as consistent with GSR have compositions that are also found in particles from a number of relatively common non-firearm sources. Particles within this group are produced through the operation of a variety of processes, equipment or devices, and can be found in the environment with varying levels of frequency. Particles classified as commonly associated with GSR have compositions that are commonly found in the environment from a number of sources. However, when present, in addition to particles that are characteristic of and or consistent with GSR, these particles can be of significance in the interpretation of a population of particles and consequently the likelihood that the population is GSR. In isolation, however, such particles have little significance in the examination of GSR. And that is the first time we see that. And then the definition at page 19 in the report 3894 of particles consistent is at the bottom of that page and over to 3895. And the definition of other particles, sources of particles with composition similar to GSR, and that is at page 3896. And this was a passage cited in her report by Ms. Murtha. The first limb of that report was cited, together with the last sentence. And the passage that she missed out in that report is the sentence that starts, however, an extremely small number of particles originating from such sources can be very similar to or indistinguishable from GSR. In other words, that's the passage that indicates you can even get 3-component particles at random from other items in the community as a whole.
Sorry, can you help me to find that sentence? I'm struggling.
Yes.
It's
page 3896.
Yes.
It's under the heading, it's the second heading down, sources of particles with compositions similar to GSR. So
yes.
It's actually page 21 of...
yes.
And it's in the middle of that paragraph.
She
cited in her report the first limb of that paragraph and the last sentence of it, and Ms. Shaw made a point of putting in the sentence in the middle, which we say is, of course, all important.
Your point on this, I think, is it, Mr. Wood, that Miss Murtha, in her latest report, along with Miss Elsel,
yes,
has misunderstood this particular passage?
Absolutely.
Yeah.
Absolutely. Absolutely. My Lord, that deals with that. Can I then take your Lordship back to, we start to get into the ASTM guidance, and of course these are now we're into post-trial guidance. You've got the reports of Ms. Shaw about the researches that are done, and the ASTM, my Lord, is the American Society for Testing and Materials. It produces it's the international body, effect, charged with not this subject alone, with many subjects in putting this kind of guidance.
Well, it certainly has international aims, but I mean, there isn't any kind of general international acceptance for any of these topics, is there?
Well, my Lord, the Europeans have different and far tighter standards, as I understand it. But, my Lord, I think one could go on looking round, but this history will simply take your Lordship to how we get to the latest guidance.
Yep.
My Lord, at page 3866 of the bundle, and I want to assist with a confusion so far as this is concerned, because the copy that is in was placed into the electronic bundle, my Lord, does not have the paragraph numberings that appear in most copies of this document, and I had sent to me, and I know are available, copies of both of these, all of these reports in the form with numbered paragraphs. Under paragraph 3 is where it's important.
This is the 2017 version of 1588, is it?
Yes, 1588, my Lord. Yep. There are references to paragraphs 314 when citing this in Ms. Shaw's report, and this copy, for some reason, does not have the paragraph numbers on paragraph 3 in it. And I've been sent a copy of the class, and when she cites 314, 314 is the paragraph commonly associated particles,
which repeats the same formula that we've just seen in the.
And my Lord, if one goes to page 3871.
Sorry, page?
3871. You find the most recent version of E1588. And I should say the difference between this and the report produced by Miss Shaw is that this is gunshot residue analysis by scanning electron microscopy. And you can see again, and it's not numbered under paragraph 3, but should be, 314 of the 2020 version, which is this one at page 3871, has a slightly different phrasing. When present in addition to particles that are characteristic of or consistent with GSR or both, these particles can be used in the interpretation of a population. And then again, the paragraph about in isolation. And then, my Lord, we have the report produced by Miss Shaw in her third report to your Lordship, which you have at page 3436. And this is guidance, as I understand it, it is the first 3309 guidance, and it's to be distinguished from the analysis of GSR guidance that we've been looking at, because this is guidance for reporting on forensic primer gunshot residue. So one is about analysis and one is reporting, although that's the difference in title and why there's a difference in number. And my Lord, it's structured in the same way. It's published on the September the 1st, 2021. It has the paragraph about terminology, threshold, and the like. And then over the page at 3437, it starts on interpretation. And I don't need to deal with paragraph 5.5 particularly. It's dealing with characteristic PGSR. It deals with interpretation of full throttle GSR, if I can put it that way. 5.5.2, interpretation can be drawn from the identification of PGSR particles on a recovered sample from an inanimate object, and then it gives draft wording. And then it gives 5.5.2.1. It gives, again, examples of wording, and I read out paragraph 5.5.3 in full. Interpretation can be drawn from the identification of consistent PGSR particles, in other words, particles 2, with 2 elements, on a recovered sample from a person. Included wording stating that the identification of interpretation 1, the person discharged the firearm, etc., etc. The number of confirmed particles cannot be used to determine which of these scenarios is more likely. That is important. And if we go to 5.5.4, we draw attention to the last sentence. The absence of PGSR particles supports the theory that an item was not exposed to PGSR. Then under 5.6, no interpretation can be drawn from the identification of particles that are commonly associated with PGSR. This includes lead, barium, antimony particles found in isolation in the absence of characteristic and consistent PGSR particles.
Sorry, where was that?
That is the bottom, the left-hand column at the bottom of page 3438.
Oh, 5.5.6, point 1.
5.5.6.
Yes.
Is the reference to absence in 5.5.4 something of a departure from the general approach to scientific forensic science evidence?
I think it's a question of balancing the two propositions. It's supportive of the contrary proposition.
But the general approach, surely, is that the absence of evidence is not evidence of absence.
Yes, and I'm well aware of what was said by Lord Justice Leveson about that in Dwayne George. But, my Lord, that is the position of the scientific community as of today. Okay.
Mr. Wood, can you help me in relation to 5.5.3?
Yes.
What interpretations can be drawn from the identification of consistent particles? That is, two component particles, as I understand it. And is this saying that you can draw a conclusion from that it's consistent with the discharge of a firearm? Yeah. That the person discharged the firearm?
Well, in my submission, that can't be. Yes. Oh yes. I'm grateful. Page 16. Of Angela Shaw's last report. And I'm told that deals with that. And it's to do with. I'm going to come back to Your Lordship on that question. Can I do that?
Yes, I'd be grateful. I'm a bit puzzled at the moment.
Yes, no. I agree, and it'll be something that I will deal with over the luncheon adjournment.
Thank you.
My Lord, I want to move forward, being aware of my time so far as this aspect of the court is concerned. Having taken Your Lordships through the guidance, I turn to our submissions at paragraph 4.3 as to Ms. Shaw's evidence, and we set out the areas in 4.3 reporting 3346.
Thank you.
I do apologise, my Lord.
3340.
3346.
Thank you. Yeah.
We set out the areas that her evidence deals with and supports, and what it informs. And we give examples of where it's informing and why it is informing. And my Lord, can I just take Your Lordships to subparagraph 4 over the page at 3347. We contend that she supports the proposition that the 5 GSR particles found on Mr. Dill's clothing did not support an inference that the particles found on the appellant's clothing came from a firearm.
Now, where's that derived from? That's your summary of it, which is very helpful. Where's the raw material?
I was going to take Your Lordships to the reference, and I'm sorry, I don't have that. That's a second pointer.
It's part of the problem, Mr. Wood, of trying to cope with this on paper when there seems to be a difference between the various scientists. But you see, somewhere, presumably, there is a basis in Miss Shaw's report for proposition little Roman 4.
Yes.
Well, it's your conclusion, isn't it, from what you describe at Roman 3?
Ms. Shaw explains that one component and two component particles are found with GSR particles only if they, and that is, yes, my lord, there's the reference, answer 13A 3405 to 3406. I do apologise, my lord.
Very helpful, thank you.
And that is the reference where she deals with it, and that should answer the question.
But then looking up just above that at little Roman 2, you report Miss Shaw as agreeing that the presence of one and two component particles are only significant when found with what you call GSR particles, by which
that is three components.
You mean three, don't you?
Yes, absolutely, my lord.
How does that stand with what we've just been reading in all the guidance?
Well, my lord, our submission is that is the proper position.
But the guidance says that the ones may support either twos or threes.
Yes, and that's what she's saying in my submission.
Well, it's not what you're saying in that argument. You're saying there that unless you've got a 3, you can't look at anything else.
Well, my lord, that is our submission, that yes, unless you've got a 3, you shouldn't have the real thing. My lord, if you're going down reporting and using 2s and 1s alone, and I have to say there are only 3 items in this case for my client where there are 2s and 1s. 4. Yeah. So out of the vast majority of them, my lord.
Back to what is an item and how closely they have to be defined.
Yeah. What is a population?
Well, my lord, what is a population is a core element of this, and what one can do is look at internationally what is happening with this evidence. And our submission is that Bermuda stands out with the thrust of international way this evidence is dealt with. But, my lord, I wanted to take your lordships to paragraph.
Well, in relation to the 3 or 4 items in which there were a combination of 1 and 2 component particles, are you saying that was admissible?
Yes, we're saying it should not be admitted. We say that should not be admitted. And, my lord, can I take your lordship, please, to the passage which I was going to take your lordships to, at subparagraph 4, where we say, therefore, the judge's direction to the jury that they did support that conclusion at 179:20 to 83, and the Court of Appeal's ruling had no scientific basis. And, my lord, I should take your lordships to that passage where the judge gives that direction, and that is at page 79 of the summing up, where he says, so you might think, and that's 79, line 20 over the page, so you might think that 1, just because 5 3-particle components are on one defendant and no 3-particles on the other, but that they both have all these particles, that the principle that the GSR experts speak about, that is, that where there are 3 component particles and the other evidence may be supporting evidence, may very well apply in that case in respect of both men. Or you go the other way round, and then he postulates it round. Our core submission is that is an error.
You may have other points about the summing up, Mr. Wood, but as to that one, if he had simply read out what the ASTM guidance has said, he'd have been saying exactly the same, wouldn't he?
Well, in my submission, he went too far, and we've made it in our case that is.
All right.
And
My Lord,
can one entirely ignore what the judge went on to say in lines 4 to 13 of...
yes, my Lord, he went on to say that posited the opposite position.
Yes.
As contended for. My Lord, we've set...
And his conclusion was, at line 10, you look at the evidence separately, by which he means separately in relation to each defendant.
Yes. But, my Lord, what he's done then and later is group it all together. My Lord, we invite your Lordship's full attention to, obviously, the first report of Miss Shaw. The second report of Miss Shaw is to be found directly behind the first report, and it is in that report that she highlights the findings that were made in Bermuda. The full findings are set out in 3419.
Yeah.
How many two-component particles did she find?
2.
Out of
20 samples.
3419.
3419 are the findings.
I think you told us this is everything she found.
These are what she found, yes.
For some reason, there's an awful lot of antimony at the airport, but that's...
Yes. My Lord, then appended to that, your Lordship will find a map of where the samples were taken around Bermuda. And that's at page 3425 through to page 3430. My Lord, you then have the third report of hers, in which she exhibits the latest guidance and draws attention to what it says. My Lord, finally, in terms of the fresh evidence we seek to admit, you have the evidence of Tara Halsell from the R.J. Lee Group. It's the transcript that runs at page 3443 through to page 3515. And my Lord, we've set out in our case the references to the core passages, and I have taken your Lordships to the guide so far as that is concerned. The approach that has been adopted now by the laboratory is indicative of the very low probative value that the single particles have. And I will invite your Lordships to have regard to that fresh evidence. My Lord, can I turn to page 13 of our case about the admission of the evidence?
Presumably you're also seeking to admit the 30th of January.
I do, in answer to it, my Lord, yes. The final report. My Lord, can I take your Lordships to the legal principles? So far as the admission of fresh evidence is concerned, there are statutory provisions which your Lordships have. The court has power to admit under section 8.2, which your Lordships have, with the Bermuda, the power of the court to admit fresh evidence. And I'm at paragraph 415, my Lord, of our case. and that is set out at page 3554 of the electronic bundle. It sets out that the power of the Court of Appeal, which is the same as your Lordship's powers, is that as set out at, in the section there referred to. And, my Lord, you then have the Bermuda Criminal Appeal Act at page 3556. At section 16, subsection 2. If in conjunction with the hearing of any appeal upon the application of the appellant, or subject as hereinafter in this subsection provided to the respondent or any person made an additional party to the appeal, it is made to appear to the Supreme Court that in the interests of justice it's reasonable to do so, the court shall supplement the procedure mentioned in subsection 1 by any or all of the following means. And that then is about allowing fresh evidence in, my Lord. We say when considering whether it is reasonable in the interests of justice to admit fresh evidence, there are various matters to which the court will usually have regard, and that is whether the fresh evidence is capable of belief, and I'm sure your Lordships will be familiar with this test, whether there was good reason for not deploying the evidence earlier in the proceedings.
Is there any evidence of any reason in this case?
My Lord, yes, absolutely, and that is that the issue was developing and it became absolutely clear subsequently, and you can see the reasons that have come about subsequently, the change in practice that there's been, we say, the status of the new guidance, all of which in our submission is quite proper to lay it.
What is most of Shaw 1 new?
Yes, in our submission, absolutely. This is it shows the framework, and we submit that it illustrates to your Lordships exactly how things have moved forward and changed, and how the practice which have been adopted and assumed to be correct in Bermuda is manifestly wrong.
The symposium was in when?
The symposium set far higher standards, and that was in 2005.
Ms. Shaw deals with contamination, and all that isn't new. None of it's new.
No, well, I accept that, my Lord, and that's not the thrust and the...
And so what is the essential bit that's new?
All the guidance and the interpretation of the guidance.
No, the SWG document is what date?
2011.
2011. Right. And our trial is?
2013.
Yes. I mean, I can understand this, or at least I might be able to understand the submission that you hadn't got, that it wasn't widely known, but it wasn't new, was it?
Well, in our submission, this science has developed, and it's appropriate to admit this fresh evidence. The Bermuda survey findings are wholly new, my Lord, and they illustrate something that wasn't known about at the time at all.
Well,
but the Bermuda study could have been done before the trial, couldn't it? There's no suggestion that that wouldn't have been found if it had been done earlier, is there?
Oh, my Lord, absolutely no funding for anything like that at all.
Right. No, I follow that.
In the manner in which it's been done and funding found for to enable it to be done, having regard to the widespread use that was going on to establish the background prevalence of these particles in Bermuda was difficult and complex. And your Lordships will also see the development of this from the answers in question 13 of Ms. Shaw, about what was actually happening in Bermuda to try and find out the background levels, which people thought this may all be consistent with.
But I follow that you can't, that it may not have been practicable for Miss Shaw to go and examine the bar stools and so on earlier than she did. So I would have thought she might. But the proposition that the elements, barium, antimony and lead, were common in the environment everywhere was absolutely known in 2010, wasn't it?
Well, that was Miss Murtha in her evidence.
Yes, exactly.
That it wasn't background.
No, she gave evidence that the reason why the two component particles were not stronger than they are, and the one component particles even less, was that all this stuff is to be found in the environment. There are lots of other causes for it.
Yes, but what was never established was that there were background levels that anyone would have. It was about contact, and we get that with the trial judge saying in his summing up, are they so unlucky to have come into contact with all these people and so forth, highlighting the position.
Have they been renovating brakes?
Absolutely. Have they been renovating brakes? Have they been getting oil?
Absolutely.
Have they been doing all of that, my lord?
I'm with you. Well, I say I'm with you. I follow all that. But surely the proposition that there was these elements were common in the environment was absolutely known and has been for years.
No, it went so far that she was able to say that it was consistent with a firearm and that it was unlikely to find it, and she would not have on anyone's hands, expect to find on anyone's hands any of these samples.
Wouldn't expect generally the average person to have any.
Absolutely.
What she said. And is anybody differing from that?
Oh, absolutely, my lord. From these background findings, we can expect absolutely to find it.
No, I'm sorry, I don't see it. Are you telling me that the findings of Miss Shaw in the various bars that she visited and the components that she found demonstrate that the average Bermudian will have this stuff on him?
Yes.
All the time?
Yes.
Really?
Well, my lord, if it's there, in those random locations, that frequency, there were only 2 samples that had nothing, I believe is the position, on them. None on them. Only 2 samples. Yes. My lord, it's there in the background. We're all likely to have it on us. And that's what has not been understood about this material, and why there needs to be exercised real caution about the admission of solely 1 and 2 elements and 1 component.
Is that a topic on which you say there is a scientific consensus? I know it's what Ms. Shaw says.
I do say there is a scientific consensus about it, absolutely. But it's one that has emerged since this trial in 2013.
And is it to be derived from the various reports that you've shown us? The guidance, really?
And the guidance, my lord, yes.
Oh, it's to be derived from Ms. Shaw's report. I understand that. But where is it in the guidance?
Well, my lord,
most people have got it all the time.
Well, it's from the interpretations that are made, my lord. It's how to interpret that material. What people can say about it.
Okay. Yep.
Taking you back to the judge did direct that, or postulated that both Mr. Hewey and Mr. Dill would have to have a contact with various activities, as opposed to just being in the general environment. Was there any scientific evidence supporting that direction?
None given in the trial, my lord, no. None given in the trial at all. My lord, our submission we set out further at page 14, page 3352, some of the aspects of of why it's in the interests of justice to admit this material. And we set out at paragraph 420 some of the reasons, 418 through to 422, the reasons why we say it's in the interests of justice that this material be admitted. And we identify at paragraph 420 some of the examples, and I take your lordships to that at page 77 as just one illustration of the approach of the trial judge, where he described the prosecution, the defense expert, Mr. White, as a hired gun.
Well, hang on, Mr. Wood. He'd been cross-examined on that basis. Or rather, sorry, Miss Merthyr had been cross-examined on that basis. And don't forget, you're in the neck of the woods adjacent to the United States, where there is no concept of the expert's duty to the court. And sadly, the kind of cross-examination which whoever was representing Mr. Hewey, I think, on this occasion, directed to Miss Merthyr is not surprising. You always give evidence for the prosecution, don't you? It's foreign to English eyes, and we are perhaps rather lucky. But it's not uncommon, I'm afraid, in the United States.
Well,
and what the judge is doing there, I mean, there's lots you can say about the summing up, but what he's doing there is picking up the cross-examination.
Well, my lord, and reverting it obviously round the other way.
Yes.
Making sauce for the goose, sauce for the gander.
Yep.
If your lordship is correct so far as that is concerned. Our submission is that the jury received a confused picture of the science, and in our submission, the picture that emerges from the fresh evidence, which impacts strongly, we say, on our grounds, is a clearer and important position, and we invite your lordships to admit all of that evidence. My lord, I'd propose to move then to dealing with our grounds, and particularly to ground one. Our ground one is that the one component and the two component particles should have been excluded. According to industry standards we submit, one component and two component particles, when accompanied by three component particles, can be supportive of the fact that the particles, and we emphasize on that standard, came from a discharged firearm. My lord, we take your lordships and give your lordships attention to answers 13A, B, and C of the Ms. Shaw's first report in that connection, where she says, my lords, at page 3405, can you explain what he means by, in connection with Mr. White's evidence, found with or found in addition to three component particles? Does that mean in the same sample or the same item? And she, at page 3406, says she presumes Mr. White meant found in the same sample or item as the three component particles, and she then cites the ASTM guidance in support of that. The above refers to particles found on samples taken from the same item. It would not be best practice to collectively report particles found on a number of items recovered at different locations or from different suspects, and hence elevate the number of particles and the number of locations as supportive of originating from a firearm source. And then she goes on over the page to deal in more detail. Miss Murtha, at page 793.
Am I correct that the guidance just refers to population and the words samples and items are used by the witnesses, by the experts?
Yes.
So we should really be concentrating on population, should we?
Well, my lord, population has no definition within the materials. And Miss Shaw gives clear evidence, as did Mr. White, effectively, that it meant samples.
Well, items, at any rate.
And Alison Murtha, in fact, said the same thing in the section of her report that I took your lordships to earlier, present on the samples at page 794. In our submission, the findings were not just inconclusive, but were totally neutral. The presence of one component and two component particles in isolation is not merely inconclusive as to whether or not the articles originated from the firearm, in the sense that one cannot be sure or certain that the particles came from a firearm. They are not conclusive of coming from anywhere or anything. And I take your lordships to that reference. In the evidence of Mr. White at page 2906, where he said, these particles, as I mentioned earlier, exist in many areas of nature, not background, I say, make clear, and you might find them on an item. I don't really understand the question yet. And then over the page, he goes on to talk about it, and he's saying he believes he answered the earlier question, and that they could have come from a discharging of a gun, but they could have come from many other places. No GSR particles were found on the appellant or on his belongings. Only one component and two component particles. And as such, the one component and two component particles were neutral evidence. And our submission there, and I'm at page 17, my lord, I'm at page, no, not, I'm at page 3354 of the electronic bundle at 6.3. As such, the one component and the two component particles were neutral evidence and had no probative value. And the trial judge and the Court of Appeal, we submit, failed to understand that. My lord, can I take your lordships just to the case of Barry George? It's in the authorities bundle at 3582. Oh. Yes. And to page 3587, my lord, where the Forensic Science Service guidance is clearly set out, And the conclusion that the guidance effectively on reporting of single particles and low level, the concerns there was of full GSR was something the court relied upon then in due course in finding at paragraphs 36 to 39 that in effect the evidence was given. We believe that the manner in which Mr. Keeley gave his evidence was likely to have left the jury with the impression that his view was that because you could not discount each possibility of innocent contamination as most unlikely, the likely source of the particle was the gun that had killed Jill Dando.
Yeah, I mean, the point about Barry George is, quite apart from the fact that it's one particle a year later, but the court's finding is that the scientists over-egged the pudding substantially.
Well, my lord, we say not only did the scientists over-egg the pudding, not about full GSR, but about even less than there was in Barry George, and the trial judge did so too. Because in Barry George, what they were talking about was one full 3-component particle. Yes. And here what we've had is 2 and 1 component particles at a level consistent with that disclosed in the background reports in Bermuda prepared by Ms. Shaw from the 2017-18 particles that were taken.
Subsequently, yes, I see.
So subsequent to the hearing. In this appellant's case, we simply make the point that no GSR particles were ever recovered for interpretation. At paragraph 6.5, we deal with the case of Dwayne George, which your lordships also heard. That case involved 2 actual particles of GSR on a single item, supported by 2 particles of consistent. In other words, 4 particles, 2 of 2 component, and 2 of 3 component, supportive of the proposition that we make about when it's proper to report and give evidence as to conclusions so far as that is concerned. At page 3673, the court ruled the fact that scientists have adopted a cautious approach to reporting low levels of residue, 1 to 3 particles, such that for the residue on its own, no evidential significance can be attached to it, does not mean that the evidence is necessary, inadmissible, or irrelevant. Still less is that the case when, as here, there were, in fact, a total of 4 recovered particles, albeit that 2 are characteristic of gunshot residue, and 2 indicative, to say nothing of the additional particles found by Ms. Shaw. The jury are more than able to assimilate. So this is the admissibility argument, and then the court turned at paragraph 48 to the way it was left, ruling that it was inappropriately left. Now, my lord, in our case, those articles were all on one item, on one exhibit. They assisted in the interpretation of that exhibit. So we have a position whereby grave reservation about reporting even low levels of items, and what was happening here was hundreds of single component particles consistent with background levels were recovered. Everybody would have been in this position, and that's why this conviction is so unsafe.
Well, wait a minute. What happened in Dwayne George? They had the benefit of Miss Shaw's assistance, didn't they?
They had Miss Shaw's assistance as to the interpretation that had happened, and they ruled that effectively we endorse Mr. Whittam's broad proposition that the change of approach to evidence of gunshot residue does not necessarily determine the appeal. Yeah. And that was about the levels, the low levels that should be reported. That change is a change that has happened since the trial too, our trial. Ms. Shaw had the present scientific concerns explained by Ms. Shaw been available to the judge, we have no doubt that his directions would have been couched in terms of much greater circumspection and caution. The particles of gunshot residue may well be consistent with the appellant's participation in the murder, but at the very least, the extent, if it got that far, to which they could provide positive corroboration would now have required much more detailed analysis of the scientific evidence.
So the decision there is admissible, but,
yes,
but needs a more careful direction than it's possible for Mr. Justice Henry Davey to give because he hadn't got the evidence of Ms. Shaw.
Never in other jurisdictions, so far as we can find, have one component particles been admitted. And we say, my Lord, that the reality here is that one component and two component particles, save where they are there to inform actual gunshot residue, should not be the subject of admission in evidence because they do not prove anything and they have an enormous prejudicial effect. My Lord, my watch says 1 o'clock. I don't know whether that's a convenient moment. It is certainly so.
Well, mine says 1 minute past, so I think we'll adjourn to